Today, we are diving into what is arguably the most important legal fight of our time, the high-stakes battle over the data that is fueling the entire generative AI revolution.
So let's just get right to the heart of it with a question for every creator, every lawyer, and really every investor tuning in right now. Is your intellectual property being used to build the very engine that might one day replace you?
All right, our investigation starts with a concept that many people are calling an invisible heist. The argument here is pretty stark, that the mass scraping of basically all of human history to train these AI models isn't fair use at all. It's being framed as a systematic, global-scale theft. We're essentially watching the commoditization of the human mind.
Now, to really get a grip on this, you first have to understand what's actually being taken. Think of training data as the new crude oil of the digital age. We're talking about absolutely massive data sets, scraped from every corner of the internet, and they contain billions of copyrighted works, everything from books and articles to photographs and source code. This is the raw material used to teach AI models.
So let's get into the forensics of it. How does this so-called heist actually play out? Well, the technical process itself, it's really less like a person learning and a lot more like a mechanical, industrial-scale act of copying and encoding information.
It really boils down to a three-step process. First, you have the scrape. Automated web crawlers like the enormous Common Crawl project just systematically copy data from all over the web. Second, that content is tokenized. It's broken down into these little numerical pieces. And third, the model is trained by crunching all these tokens to map out statistical patterns. And just like that, raw, often copyrighted material gets turned into a functional AI model.
And what's so fascinating here is how this visualizes tokenization. You can literally see the words from a classic novel, A Tale of Two Cities, being turned into a string of numbers. This really drives home the point that the process isn't about understanding the story's meaning. It's about converting human expression into a purely mathematical format that a machine can process.
And this quote from Jacqueline Charlesworth just nails the core legal argument from the creator's side. The original works, they don't just disappear after training is done. No, they are permanently encoded, token by token, right into the DNA of the model itself. They literally become part of the machine.
And that brings us right to the legal battlefield. The whole war is being fought over Section 107 of the Copyright Act and its absolutely crucial four-factor test for fair use.
Now look, fair use isn't some kind of get-out-of-jail-free card. It's supposed to be a critical balancing act in copyright law. But to claim it, AI companies have to survive this incredibly rigorous test. Factor 1, the purpose and character of the use. 2, the nature of the original work. 3, how much of it was used. And 4, the big one, the effect of the use on the potential market. Pretty much every single lawsuit out there hinges on these 4 points.
And the whole conflict really comes down to this one central question, especially on that first factor. AI developers claim what they're doing is transformative, creating something totally new, like a search engine. But creators fire back that the use is substitutive. It creates outputs that directly compete with the stuff used for training. So, is it transformation, or is it just flat-out replacement?
Okay, so let's talk about how a recent Supreme Court decision completely changed the game. It turns out the ghost of Andy Warhol is now haunting the fair use defense, and it's given copyright holders a powerful new weapon.
You see, the Supreme Court's decision in the case Warhol v. Goldsmith, it dramatically narrowed the definition of what counts as transformative. The key takeaway, the thing everyone is focused on, is this. The court zeroed in on commercial purpose. If the new thing and the old thing share the same commercial purpose, it's probably infringement. Simple as that.
And this is a perfect illustration of how that Warhol test applies to AI. So, imagine a model is trained on a specific photographer's entire portfolio. Then, that model is used to generate and sell new images in the style of that same photographer. Well, now the original work and the AI work are competing in the exact same market. The commercial purpose? It's identical. And that precedent has completely changed the economic calculus for everyone involved.
So that Supreme Court decision really gave creators the legal firepower they needed to push back, and it's forced this huge economic realignment. All those old Wild West arguments are starting to fall apart, and what we're seeing instead is the incredibly fast rise of a formal, licensed market for training data.
I mean, just look at this timeline. It shows this stunningly rapid chain of events. In 2023, the Supreme Court drops the Warhol decision. Just a few months later, the New York Times sues OpenAI and Microsoft. And now, You're seeing major publishers like Axel Springer signing these massive multi-million-dollar licensing deals. The entire industry is changing right before our eyes.
And if you want to know why, well, here's the smoking gun. This side-by-side comparison is a key piece of evidence right from the New York Times lawsuit. On the left, that's output from GPT-4. On the right, that's the original Times article. It is a nearly word-for-word copy. This is the kind of thing that proves these models can, and absolutely do, memorize and then just regurgitate their training data, becoming a direct substitute for the original source.
And this brings us to what might be the killer point, the emergence of this new, thriving, multi-million-dollar licensing market. It just completely guts that fourth fair use factor, the one about the effect upon the potential market. It's getting really hard for AI companies to argue there's no market harm when a massive market for that exact data now clearly exists.
And the financial stakes here are just astronomical. The New York Times is seeking damages that are estimated to be in the billions of dollars. Yeah, this is not some theoretical, academic debate anymore. This is a high-stakes war over property and revenue.
So we're left with one final provocative question. Now that a formal, licensed market for data is a reality, and with AI companies actively paying some creators for their work, can they still claim fair use to take the rest for free? Or is that defense now effectively obsolete?
All right, so we've been digging into how to protect our work from AI. But here's the thing. That best practice everyone keeps talking about, it's a flawed defensive strategy. Honestly, it's a losing game. So let's just dismantle it right now and talk about a much, much better way forward. Okay, so a huge piece of this defensive puzzle comes straight out of the European Union. It's called the right to opt out. And the idea is pretty simple. Creators can just slap a do not train tag on their digital stuff. And if an AI company ignores that tag, boom, they get hit with these just massive, catastrophic fines. Sounds pretty great on the surface, doesn't it? Like finally a real legally backed shield for all of us.
Yeah, but it's not. In fact, you could even call it a trap. Think about it. You're basically just asking these multi-billion-dollar tech giants, pretty please, don't use my data. That is a fundamentally weak position to be in. It's a losing strategy from the get-go. And trust me, there is a much, much better way. And that's where we get to the absolute core of the sovereign strategy. This requires a total shift in how we think about this. It's time to stop trying to build these flimsy walls to keep AI out. We've got to stop playing defense and go on the offense. It's time to stop building walls and start building a gate, and then charge admission. So let's break this down, because the contrast is everything. The opt-out model, that's passive. It's basically a request. You're asking a machine not to learn from you. But opt-in and licensing, now that is active. That is a straight-up power move. You're not asking, you're granting permission. On your terms, for a price. See the difference? You're not requesting, you're commanding. And hey, this isn't just some theory we're talking about. It is already happening. We are literally seeing the rise of what are being called data unions. You can think of them like modern-day guilds. You've got these high-value professionals, lawyers, medical experts, artists, all pooling their intellectual property together. They're creating these massive licensed ingestion pools so they can negotiate from a position of incredible strength. And this just sums up the whole philosophy perfectly. Forget about trying to fight the endless, exhausting tide of data scraping. It's just futile. The smart move, the sovereign move, is to build a toll booth right at the front gate of your valuable data. You monetize the machine's insatiable hunger for knowledge. Okay, but this isn't just some clever business tactic. You have to understand, the entire legal battlefield is shifting right now, and it's shifting in a way that makes this proactive, offensive strategy incredibly powerful. So for anyone who's been watching the legal trends, this stuff is huge. The courts are starting to move away from just blaming, the random person who used the AI. Instead, they're looking at something called vicarious liability. And what that means is the AI companies themselves are being held responsible for what their systems create. This is leading to very real talks about compulsory licensing, kind of like how the music industry works, and what's shaping up to be a pay-per-train economy. All the risk is getting pushed right back onto the tech giants. And the legal bedrock anchoring this whole thing is a super fundamental principle. A machine cannot be an author. It just can't. Copyright is and will always be inherently human. This is the human in the loop concept. So even if the person using the AI can hold the copyright for what's generated, the company that owns the machine is absolutely on the hook as a defendant if that output is infringing on someone else's work. That is the leverage. That's the whole game.
All right, so let's set aside the legal arguments for a second, because there is a massive economic force at play here that is making your data more valuable than it has ever been. We're not just talking about protection anymore. We're talking about an entirely new class of wealth. Which brings up a really critical question, right? In a world that's absolutely flooded with AI-generated content, why is human-created data suddenly becoming so scarce and so valuable? What's the fatal flaw in the AI ecosystem? The answer has a name. It's called model collapse. You know the old saying, garbage in, garbage out? Well, what's happening is that AI models have started training on their own AI-generated garbage. They're feeding on their own synthetic, nonsensical outputs. They're literally poisoning their own data wells. And this leads to a massive drop in quality, bizarre outputs, and what you can only really describe as digital stupidity. So what's the antidote to this model collapse? What's the cure for this digital poison? It's you. It's your human-verified, high-quality knowledge. Your archives, your legal briefs, your design portfolios. These are not just records of your past work anymore. They are the gold standard. The premium training sets that AI companies are desperate to get their hands on to keep their models from going completely off the rails. And here's the bottom line, the real takeaway. The next wave of wealth for knowledge workers and creatives, it's not just going to come from billable hours or new projects. It's going to come from what we can call ingesting dividends, royalties that get paid out every single time a machine learns from your unique, proprietary, human-verified expertise. So let's bring this all home. When you look at all these legal and economic trends, they're all pushing us toward one single verdict. It's a clear and frankly urgent choice. Are you going to be an architect of your digital future, or are you going to be a victim of it? And really, there's no middle ground here. There's no wait and see. We are at a fundamental crossroads for the entire future of intellectual property. Path A. That's the default path. It's the path of playing defense, of just hoping for the best. And that path leads to the total erosion of intellectual property, where everything we've ever created becomes a sort of statistical ghost owned and controlled by a few tech giants. But then there's path B. That's the proactive path, the Sovereign Council's path. It's all about restoring ownership and deliberately building your own personal digital estate. You are not a bystander in any of this. You are the architect. And this isn't some abstract, far-off battle we're talking about. The front line is right here, right now. It's the battle for control over training data. Your training data. Your intellectual legacy. Because make no mistake, the machine is learning. Every single day, the only question left is, are you going to let it learn for free, or are you going to make sure it pays for the lesson?